Should we start, sir?
Yes, please start. Please start.
Good afternoon, everyone. I, on behalf of ICFI Law School, extend my warm welcome to all at day one of 3 days workshop on insolvency and bankruptcy and its legal implication. I would like to welcome our speaker, Professor Dr. Shushmita Malaya, and our Dean in charge of ICFI Law School, Professor Dr. Yugal Kishore. Sir has been Registrar and Vice Chancellor of National Law University and Judicial Academy, Assam. I would also like to welcome our academic coordinator, Mrs. Monica Carola. She has been with ICFI Law School since its inception. Prior to this, she was at Lal Bahadur Shastri National Academy, Mussoorie. Now I would request Dean Sir to kindly introduce our respected speaker and take this workshop forward. Thank you.
Okay. Thank you, Stuti Tiwari, Madam Stuti Tiwari. So I take this opportunity to express good afternoon to all of you. And I, Professor Yugal Kishore, Dean in charge of ICFI Law School, ICFI Law University, Dehradun. Welcome, especially our very learned professor, Madam Shushmita Malaya, and Madam, our academic coordinator of ICFI Law School, Monica Carola, and Stuti, one of my esteemed colleague, Miss Stuti Tiwari, and all the participants from different nook and different corners of the university, and my student friends. Now, today we are organizing a 3-day workshop on IBC, that is what we call it as Insolvency and Bankruptcy Code. In fact, during this period of COVID-19, it has become a very important aspect because many of the industries and banks, they are at the verge of getting bankrupt because of there has been no business in the last 3-4 months, and we do not know how long this will continue. So therefore, India has also taken some initiative which we'll discuss later on. But at present, I would like to introduce something about our law school and law university. So initially, if you look at बेटा मैं नहीं आ रहा हूँ, अभी आ रहा हूँ क्या? मैं आ रहा हूँ वहाँ पे? I am visible there.
Yes, sir.
Yes, sir. You're absolutely visible.
I am visible. Okay. So this ICFI Law School was established in the year 2004 when the ICFI Law University was established by one of a very great institution builder, Mr. N.J. Yashashwi, who has established as many as 13 universities in India, and he was instrumental in establishing this university in the year 2003. And thereafter, the university as well as the ICFI Law School both have taken much more strides to develop themselves and to provide and impart quality education, not only in the field of law, but in management, education, and technology. And then after, I can very proudly say that we have been awarded this year a very prestigious global award, that is the 44th rank by World University with real impact. We call it as URI 44. So apart from that, our ICFI Law School has been awarded as the best university in Uttarakhand, as well as the 6th among top leading law schools of super excellence in national, government and private schools by CSR GHRDC Law School ranking. And similarly, we have been awarded very well by the India Today and Week survey also. So with this, and we have been recently awarded I-Lead universities. That is, we have been declared to be a very competent university as far as the online learning is concerned. Today, in this workshop, and in fact, we have organized as many as 16 webinars. These are third lecture series which we are presenting today. FDP 7 days FDP has also been organized here throughout for the teachers of the Pan India. And with that, now today we are organizing this 3 days workshop on insolvency and bankruptcy code. And on this occasion, I have got a great proud and privilege to speak that we have got a very learned professor in this field. And she is none other than Madam Shushmita Malaya. She has been working at assistant professor at prestigious Indian Law Institute, New Delhi. Earlier, she was there at Amity Law School and Vaikunt Balika College of Law, Udupi, Karnataka, Kerala, and School of Legal Studies, Kannur. Now, she is presently working as senior faculty in the Faculty of Law, Delhi University. Madam, we are very much pleased and we feel very much honored that you have spared your valuable time and you are gracing our participants here with your valuable, thoughtful knowledge. Madam, we will be, with regards to IBC, you are, of course, you are an expert, but I can say much about it, but then IBC has become, as I just told you a few minutes back, a very important law, because many of the banks and industries, corporate sectors, they were getting means they were having non-performing assets and they were not doing well. So therefore, the insolvency law which we had earlier was not sufficient to deal with. So it was decided that an insolvency code should be developed. And therefore, this insolvency code has been developed, and recently our government in the month of March has been kind enough to increase the value of the amount under which the insolvency and bankruptcy can be declared, and apart from that, a moratorium from 6 months to 1 year has been declared for the bankruptcy and insolvency proceedings. Anyway, so with this, now I request my learned professor, Madam Dr. Shushmita Malaya, please enlighten us on the topic. Madam, I may be sorry because I have been pronouncing it Malaya. I don't know it is Malaya or Malaya. So please.
Malaya, sir. It's okay.
Because this pronunciation creates sometimes little problem, madam. Please don't mind.
It's okay. No, sir, not at all. Okay, a very warm greetings and very good afternoon to one and all. It's really a pleasure to be part of this workshop that is conducted by the prestigious University IBC. And when I listen to the achievements, the academic achievements, I feel more, privileged to be to contribute a little from my part as well for this your academic journey which the institution is moving forward. And I appreciate the organizers for choosing this topic which is emerging. And sir was saying that an expert, but I will never say I'm an expert because it's only a 4-year-old child, sir. So it's like, expertise, it will take years. And this commercial subjects, it is very difficult to say that I am an expert because it's every day, every minute changes takes place in such a speed that it is very difficult to call or, presume one as an expert in this. So I will try to share my thoughts or ideas in this emerging area and an insight into this code which has been enacted. So I think that I will use the screen sharing method, because this is one aspect which I find to connect with the audience, because if it was in the live lecture, we will be knowing the the feedback instantly. But in these webinars, I think the audience will also be getting the connection if it is through the PowerPoint. So for that, I started my best to learn this sharing of PPT also. So I will try to introduce these ideas through the help of slides. I think I need to get the permission, please.
Right, sir. Akhilesh, sir. I'll just see, ma'am.
Akhilesh?
Mr. Akhilesh?
Yes, ma'am.
Yeah, please
Just
give me
announce
the permission.
Ma'am, I'm already allowing this the screen sharing. Please screen share, ma'am.
But my screen is not seen here. I'm
No,
able to
just
see the your screen only.
Ma'am, go to the green icon screen share.
Yeah.
just
So
click
there
on
only
that.
I can see that your screen is visible for me.
You're supposed to tap that only, share screen. The green.
So my screen should be visible, right?
Yes, ma'am.
Yeah, so I'm not able to see my screen here.
Madam,
Give me a minute,
when
ma'am.
you go downstairs, there will be share screen. And there you have to do, there you have to tag this one.
Yesterday it was all right. I was able to
Or else you can go for
share it.
Alt and S. That can also do.
Ma'am, actually, I'm going to the my screen share. Please see. Now visible, ma'am.
Yes.
That is the process, ma'am. Please try once again, ma'am.
Again, they are saying that this will stop other screen sharing. So I will mark yes, right? No.
Go to the screen share and click the screen. Then share the computer audio and optimize screen for the video clips. Both are the checkmark click, ma'am.
Share computer sound, then optimize screen sharing for video clip.
Yes, ma'am. Go to the share, ma'am. Yes. Now is the visible, ma'am.
Okay.
Ma'am, your audio is mute, ma'am. Please enable your audio.
Yeah.
Yes, ma'am.
Is it visible now?
Yes, ma'am, it's visible.
Visible, right?
This,
Try
Okay.
some.
the PPT isn't visible right now.
PPT is not visible.
No, madam, PPT is not
I'm
visible.
saying there's nothing on the screen.
But it shows you are screen sharing.
Ma'am, actually, right now, your internet connectivity was very low, ma'am.
Okay, just a second. Is it fine now? Is it now? Is it visible now?
Still,
No,
No,
ma'am.
madam, still is not visible.
Not visible, ma'am.
PPT is not visible.
Ma'am, you can start without PPT if that's possible, because
Tuti, do you have the PPT?
no, ma'am. Sushmita ma'am, can we?
Still it is not visible.
No,
No,
ma'am.
madam, it is not visible.
Akhilesh,
Yes,
this
ma'am.
blank screen is coming. So what could she do?
Ma'am, actually, problem with the internet connectivity, ma'am.
Oh,
Okay.
See, the internet is Geo, so I hope that it should work better.
Ma'am, we can start without PPT if that's possible.
Yeah.
I think there must be some connectivity issue.
Ma'am, please go ahead once again.
Yeah, see, now I think I will be able to share it.
Yes,
Right, ma'am.
right now
Yes,
visible.
yes,
Your
yes, yes.
internet
Yes.
connectivity is stable, good.
Yes. Okay. So sorry for the technical glitches that happened, though it should not have happened. But anyway, so this is what happens sometimes. So please have a look at this picture
Ma'am, you can
and
maximize it, like full screen.
maximize.
Full screen, ma'am.
It's maximize only.
Okay, it will work, ma'am.
It is
Fine.
working. It is working.
It's
No
fine,
problem.
ma'am. It's fine. It's fine.
Right.
Fine.
Right, ma'am.
So please have a look at this first picture. So if we look into this, we can see we will feel that it is the child labor, or that is happening. And this picture I have taken, it's just to see that to introduce the concept of debt slavery. So what happens is that it's a debt slavery can be defined as a pledge of the person's service as a security for the repayment of the debt. So generally, what happens, we won't say it's a poverty, but sometimes for the livelihood also, we may be forced to ask a kind of loan from the masters. Of course, it will be for our survival. Still, if we are not in a position to repay, what they will say that you come and join and you work for us. And ultimately, the person who has taken that debt will not be in a position to repay, and it will lead to his a kind of bonded labor or a slavery when it comes to the person. So for that purpose only, I have taken this picture to show that many a times maybe the parents of this child or the children might have taken it, but they are also forced to work just to see that they are repaying the debt. And look at the right side, the other picture. When it comes to the concept of the companies or the corporations or the small business entities or an individual sole trader, what happens? He also starts the business, and for starting the business, initial capital you can accumulate. After that, you have to expand the business, then you start borrowing, and generally we borrow from the banks, or and if it is a sole trader, from the friends, relatives, or from other persons. And of course the banks are one of the important provider or non-banking financial companies. And ultimately what happens, he may not be in a position to repay the debt that he has taken, so it will accumulate. Now ultimately, when he is not in a position to repay it, he has an option either to again survive or to close down. So this picture of the closure, that ultimately the person will not be in a position to repay the loan that he has taken or repay the debt, and ultimately it will lead to the closure of that establishment for entire. And here comes a small opportunity for any person, individual, companies, that here I got a lot of debt. So what is the best option? Is it the debt consolidation or is it bankruptcy? What I will go for? So in this picture, I just wanted to say that when it comes to the individual, it will amount to the debt slavery or the kind of bonded labor. I'm saying it's not one, it's only one of the reasons, okay, and ultimately leading to the poverty. And when it comes to the companies or when it comes to the establishment, it will lead to the liquidation of the company. And now here comes the role of the Insolvency and Bankruptcy Code. So earlier, prior to the introduction of this Insolvency and Bankruptcy Code, what was happening is that the promoters of the company were the powerful persons, and creditors remained very powerless even in case of default. And one of the important concept of the company law, if I may say, it is the corporate wheel. So nobody will say how the company, who are all the persons behind it, and always that shield protected the company. So many a times they indulged in, taking one loan after another loan, and then they are not cared, and they will venture into reckless borrowings. And this risk ventures without any concern for, without any accountability. Why? Because the laws at pre-insolvency period or IBC code was scattered or fragmented. We can see the case of Kingfisher Airlines. Earlier, the promoter, or they were indulged in the liquor business, which were very well, and then they indulged in it. So you can see that how many ventures they started taking, and without trying an effort to repay, because they were very much sure that if there are so many laws, or so you can see how many laws were there before the insolvency code, so they will take shelter. It will take, it's guaranteed of minimum 10 or 20 years the things, and by the time the result will come, it will be the position. Nobody, the creditors will not get any chance to get the assets liquefied. Okay, so in this scenario, what happened? And I would like to point out one more aspect, is that the report of the Reform Committee in 2015 also said that the limited liability company is a contract between equity and debt. As long as the debt obligations are met, equity owners have the complete control, and the creditors have no say in how the business is run. And when default takes place, control is supposed to transfer to the creditors. Equity owners have no say. Now, this IBC is a code that has been introduced by the government to see that the companies also survive, as well as, and only in the rarest of rare cases, let it be liquidated. And this code has been created because of the following reasons: because there was no single law in India that deals with insolvency law, and generally the liquidation of the companies were handled by the high courts, and individual by the different courts. And now we can see these were the legislations: sick industrial company special provision, which has been repealed, then the recovery of debt due to banks and financial institutions, Securitization Act, and the company, all these were amended. And to the one of another objective is to over the already overburdened courts, let them be not burdened with more cases coming from this. And one of the most persons, creditors who are getting affected were the banks. And all the securitization measures and all Narasimham committee report, all these committees highlighted, how to decrease the non-performing assets. However, it failed. They were not able to achieve the objective. Hence, there was, felt the need for having an insolvency and bankruptcy code. Now, this is just, a small overview of how the code has been formed. So bankruptcy, this committee was formed in August 22nd, 2014 under the chairmanship of T.K. Vishwanathan, and they submitted the interim report in 2015. And after that, the final, after going through all the process, in 2016, Rajya Sabha passed the Insolvency and Bankruptcy Code. And this is another aspect of this Insolvency Bankruptcy Code. If you just see the Competition Act and any of the legislation, even if it is passed, it will take time to provide the rules and regulations, drafting of rules and regulations, forming of the authorities. So the same was also expected, because when it was passed and in 2016, it thought that it may take years to have the rules and regulations drafted, or to have the person or the authorities under the act. But however, it was surprising from the part of the government that they acted very quickly. And this legislation has amended, I think it is thrice the amendment of this legislation. So it is, though it is only the 4 years old, thrice it has been amended. And the Insolvency Bankruptcy Board is playing a very active, proactive role, I will say, to get this code implemented and to create awareness among the business entities. And they have the major recommendations was for the moratorium, interim administration of the committee. So this I will be dealing in the next part. So the objective of this Insolvency and Bankruptcy Board was timely resolution process. As I already stated, it used to take years to settle down the matters of liquidation with the courts. And this one of the objective is the and consolidation of the multiple legislations under one code with one adjudicating authority, then reorganization and insolvency resolution of the corporate persons, partnership firms and individuals, and also to encourage the finance providers to lend money for risk taking and promote entrepreneurs. So you can see that it is actually a happy or a positive way for a company which is at the verge of liquidation to smile and come back with the new ventures or with a new opportunity or with a new life. I will say that with a new life, this code is giving an opportunity. Now, what are the highlights of the IBC? This IBC is actually a shift from the debtor in control to the creditor in control. This also I already stated. Always the debtor, after taking, you are taking the loan, but however, after that, you never ever, recognize the person from whom you have taken the debt. Then the other person will become, अच्छा हमने तो दिया पैसे दिया लेकिन उसके बाद ना आप लो फिर उसके बाद आप भूल जाओ. So this way, and if you again approach, then they will say that, and many a times what happens, the bankers again, if it is a big business person, even if there are, they were not in a position to repay, they will say, but still they, koi baat nahi, aap aur le lo, humse loan le lo. So the managers also, many a time. So it's like a caucus that used to play. And because it's a typical scenario that we can see in, our country, I'm sorry to say, that jugaad bandi to bahut hota rehta hai. So it is actually a debtor who used to control. And creditor will also say that, okay, it's not from my pocket the money is going, it's the institution. So that kind of, thoughts were there maybe. So creditor never ever got. So even after the, enactment of the SARFAESI and all, you can see every time the NPA is growing. Okay. And it is not sure that, I'm not saying that this IBC will be in a position to, reduce it and added the COVID scenario. But however, if it is properly implemented, compared to the earlier legislations, this is a legislation or a code that will help to reduce the NPAs for the banks as well. Now, the second highlight of this IBC is that it ensures the maximization of the value of assets of the debtor. Then it ensures the interest for the stakeholders. And the main important feature is the insolvency, Constitution of the Insolvency Bankruptcy Board of India. Just like the CCI, this Insolvency Bankruptcy Board of India is also established, and they are the persons who are proactively looking after how to implement this IBC. Of course, they are not the judicial power they have. They are not the adjudicatory authority, but they are the facilitators for implementing the provisions of this, and for making a table or for having a talks with the resolution process and all. And this, see, the earlier it was 1 lakh rupees. for the default was to be there, but now it has been increased with effect from 24/3/2020. Now the default amount is 1 crore. Another highlight is that it's a fast track corporate insolvency resolution process. Then it also includes the individual as well as the partnership firms. And the agency that is provided is the insolvency professional agencies and information utilities. Now, the whole structure of IBC has been divided into the 5 parts consisting of 255 sections, 11 corresponding schedules, and they are dealing with the insolvency resolution and liquidation of the corporate persons, insolvency resolution, bankruptcy for individual partnership firms. So you can see that almost all the aspects has been brought under the purview of the IBC. Now, next aspect, just to maybe since I'm told that it is the students who are the students workshop, so I just wanted to say the difference between insolvency, bankruptcy, and liquidation. So insolvency is a state when I'm saying that, see, I'm not in a position to repay, I don't have any money to repay whatever I have borrowed from you. So that is the inability of a person to repay it. And when that person is legally declared by the court saying that, yes, we also now understood that you are not in a position to repay, then it becomes the bankruptcy. And liquidation is the final process of, the winding up of the company. So insolvency, bankruptcy as such has not been defined under the IBC, but insolvency signifies the aspect where the inability of a company or an entity not in a position to repay it. And bankruptcy is the next stage where the court also agrees that yes, and liquidation is the final stage where the assets are valued and accordingly the debts are tried to be cleared. Next is the framework. So in this framework, I'm just highlighting the hierarchy. So the first is the Insolvency Bankruptcy Board of India, right? So they are the regulatory body under. So when I'm saying it is the regulatory body, it's not the adjudicatory body. Adjudicatory body is the National National Law Tribunal. Okay, National Law Tribunal is the entity where the disputes are, adjudication has been taken place. So they are the regulatory body who regulates the under information professional agencies, information utility, adjudicating authority, so insolvency professionals. So insolvency professionals also part of it, and adjudicatory authority is a distinct part. Now this insolvency professional agencies has been defined under section 3 subclause 19 of the Insolvency Bankruptcy Code, and it means a person enrolled under section 206 with an insolvency professional agency as its member and registered with the board as an insolvency professional under section 207. So this insolvency professional is again regulated by the Insolvency Bankruptcy Board. Then who are these agencies? Section 3 subclause 20 again defines the insolvency professional agencies as any person registered with the board under section 201 as an insolvency professional agency. So at present it is the chartered accountants, cost and ICW cost and works account people. They are they also have to go through the examination process that these entities are taking, and then they become the professionals. Now, so it's actually a good career opportunity to become an insolvency professional in after coming of this code. Then this section 3 subclause 21 defines the information utility. So in this information utility, it defines a person who is registered with the board as an information utility under section 210. And the person has also been defined under section 3 subclause 23, which includes a individual, then Hindu undivided family, company, trust, partnership, limited liability partnership, then the person resident even outside the India. So it has been defined. The person as well has been defined. Now, how the process of insolvency resolution takes place. So the first, a default, that is the entity or the person is not in a position to repay the debt. So now after this March, it has been increased to 1 crore. Earlier it was 1 lakh. So now, after that, they're approaching, the application is filed before the NCLT with a proof and name of the proposed resolution professional. So, and this, proposal takes place prior to the, approaching the court. And that role is played or, processed by the IBB, Board of India, Bankruptcy Board of India. And after reaching the NCLT, they can reject the application. That is 14 days from the days of application, they have option to reject, or they can admit it. And after admission of the application, then they can, after once you are, earlier it was under the sick industrial legislation. Once the company is declared sick, and after that nobody can tell or pressurize them to repay it, because they are sick. If a person is also sick, though, nobody will disturb him, right? So similarly, the companies also used to be get the tag of the sick. So in this IBC, the declaration, so moratorium is declared, and a person, that is the interim resolution professional, is appointed, and it is to be appointed within the 14 days from the insolvency commencement date. So this person, this insolvency resolution professional, is the person who takes the management of the company, and then he try to get how to go about and to have the talks with the committee of the creditors, and then manage a plan, and to see that if there is anybody who is willing to take the company and to help the company to revive, like this. And now the many a times what happens, he also faces a lot of problems, because including the employees and all, they will not be willing to cooperate with the resolution professional, interim resolution professional, or the resolution professional that has been appointed. But anyway, the act provides for and we can't insist that you should cooperate, but he tries his best to come up with a plan and to help the company to revive. And so this powers of board and management affairs has been given to him. Then all the collection of the claims, constitution of the committee. So this interim resolution professional will constitute the committee of creditors. So now this committee of creditors are, it's a very powerful people. They become the, actually we can say they are the people who will decide whether to agree or not, or how much we can, have the how much we can have the deal favorable or unfavorable, or to reduce it or not. Now, after this, the appointment of the professional, that is the resolution professional, takes place. So this is how the insolvency resolution process takes place. And now coming to the different categories of the creditors. So there are two types or two categories of the creditors, and the first and the foremost are the financial creditors. They are actually the most powerful group of creditors when the company comes into the process of insolvency, and they have under the provision of IBC and 5, and it defines that person to whom official debt owned. And on the other side, with regard to the operational creditors, it signifies that any person to whom the operational debt is owed. Now, this operational debt includes, for the goods and the services that has been purchased or has been given, and it may consist of the employees also, that like this, the development, who all will be coming under the purview of operational creditors are also many a times they have been added. So in this, the another aspect of, we can just see the distinction is that For the financial creditors, it is very easy to initiate the insolvency proceedings. They can initiate immediately the insolvency proceedings. There is no need for getting any approval and all. Whenever the claim or whenever there is a default, again now it is 1 crore. Whenever they see that there is a default, then they can initiate the insolvency proceedings. But only thing is that they need to show that there was a default and the corporate debtor was not willing to pay. Now they will form part of the committee of creditors. So committee of creditors are formed with the inclusion of the financial creditors. Whereas in case of the operational creditors, there is a distinction in the case that it is not easy. They are not part of the committee of creditors. And they have to prove that there was no dispute that was existent between the operational creditors and the debtor. So if there is some dispute or if there is any arbitration proceedings that were happening, then they will not be allowed, or then they will not get any chance to come up with the insolvency or initiate the insolvency proceedings. So this is one of the lacuna in case of operational creditors. If there is a dispute, then they cannot come, and the dispute also has been defined. Dispute has been defined to include a suit or the arbitration proceedings relating to the existence of the amount of the debt, then the quality of the goods or services, or it is relating to the warranty. So if anything, section 5 subclause 6 defines it. So if anything is there, or if anything has been shown that some dispute is there or arbitration proceedings are going on, then the operational creditors cannot initiate the insolvency proceedings. And the best part of this IBC is that in the 2018, the home buyers are also brought within the purview of the financial creditors. Earlier, financial creditors definition, the home buyers were not included. But however, this is the best positive sign that the code is expanding, and a lot of things are happening in this 4-year-old legislation. Now, another important aspect of this IBC is the concept of the bankruptcy fraud. So the fraudulent, so that's why it's an exhaustive code. It's not that it will take and of course in the workshop, I know that tomorrow also, day after tomorrow also, so the Supreme Court advocates are coming. So you can see it's a very vast area, and the vast aspects need to be discussed in order to have a clear understanding of this. So I'm just going with the theoretical aspect of this insolvency and bankruptcy code. So one aspect which I found very interesting or very relevant is that it also tries to, so this is not exactly defined as the bankruptcy fraud. You cannot find as such, defined under the IBC. But I've taken this just to see that they have included even the criminal element even in the IBC. So it's not only the financial or the civil statute, it also have the criminal aspect also enacted in this. So one is that it is relating to the concealment of the assets as defined in section 68 deals with it. So even if you have the asset, but you are not disclosing it, when the insolvency takes place, you are you try to change it in the name of your friend or your relatives, and you say that, see, I don't have anything, even everything it's in the debt, so I don't have any food to eat. You are just concealing your assets. So that will make it's a kind of fraud that many a times the companies are taking shelter under. Then transactions you are making, creditors, especially the chartered accountants will be very best persons who will be able to throw you the light in how to make fraudulent statements. So if you see it will be the profit. The company's work will show that it is in profit, but actually it will not be. And seeing the profit, people will lend more, but actually the company may not be taking very profitable manner, but still, so like this, defrauding the creditors. When the due is there, they'll say you give us more loan. So I had read that in the Kingfisher case and all, though they were debt, again they were given the loan by the banks. So, and whether it was by defrauding or not, that need to be investigation. Then falsification of books of corporate debtor, section 71. willful and material omission from statements relating to the affairs of the corporate debtor, then false information furnished in the application, receiving property from the debtor's estate with the intent to circumvent the bankruptcy proceedings, then withholding property or financial affairs from the knowledge of the insolvency practitioner. So all these aspects can be termed as the bankruptcy fraud that has been defined. And I'm not saying that all are doing, but if it is proved, and one element in this is that since it has the criminal element, you should have to prove that there was an intention. So proving of intention is a very important aspect if you want to invoke this, because if you read the sections, you can find that that has been explained there. Now coming to the landmark cases. So the first successful, so this also you can see in 2016 only the code was enacted. So it started functioning from, we can say, 2017, and the first successful case of with the help of this insolvency proceedings was the Bhushan Power and Steel case. So the Tata Steel acquired the Bhushan Power, so you can see that how the company, with the help of this insolvency. This is the classic case where there is no need for courts. There is no need for the courts or to, the plethora of cases, then take long time, longer routes. But if the people are very much willing to cooperate, and if they are able to find the financial, people who are in a position to take the company for its survival, then this insolvency bankruptcy code is a very much success in it. So this Bhushan Power Steel case has highlighted the how it can be successful. So 2016, 17, 18. So within 2 years, the first case we can see, and it is also interesting aspect that whenever any legislation is there, immediately the constitutionality of that legislation is challenged. Whether it is competition law, whether it is the Surface Act, or any legislation, you can say that it will be challenged for its constitutionality. So similarly, in this innovative industries case versus ICICI, so along with the other aspects, the constitutionality of the IBC was also challenged, because in this case the insolvency application was filed by the bank, but the company said that because earlier, as I told you, that the making the sick. So here they have this Maharashtra Relief Undertaking Special Provisions Act of 1958. So the company said that we were under that, so hence this IBC is not applicable to us. And since already we are in the sick or moratorium is there, so in the state, according to the state statute, IBC is not applicable. However, the Supreme Court dismissed it and said that the non-obstinate clause of the Parliament enactment will prevail over the limited non-obstinate clause contained in the state legislation. So this is again an example how the supremacy or the importance of this bankruptcy code, where the court also, so one thing we have to appreciate that the court also took a very quick decision, we can say, or else if they would have taken, if the decision is coming in to 2020, how much time it would have taken. But however, it's really, we have to appreciate the code has been implemented very quickly, and it has been drafted, it has been implemented, and the higher courts are also supporting it, right? And in the latest, again, the very important case, because of course in the coming sessions, I think, I'm sure that they are going to discuss all these cases, so I'm not going into the details of it. But this another landmark case which has been recently, it's not recently, but of course 2019 November, that is the SR Steel India Limited case. It's a very lengthy case, and they have resolved many of the issues. And again, the Amendment Act of 2018 has been upheld, and now this is the important thing which I have highlighted, that is the collective decision of the Committee of Creditors. So that means if the Committee of Creditors takes the collective decision, and that need to be followed, and they have the discretion to decide on the distribution of proceedings. So adjudicatory, even so you can see even the NCLAT or the National Company Law Tribunal, they being the adjudicatory authority, they also does not have, they cannot invoke supernatural powers or to take, because they feel that of course if they are coming into conclusion, then we have to say. So according to the IBC, okay, so what need to be understood is that whatever the provisions that, so there is no need for applying the interpretation of statutes to a large extent. Okay, so adjudicatory authority has to satisfy itself that whether the approved resolution plan meets the requirement laid down under the IBC, and what is the role of the resolution professional. In the resolution process, he is merely a facilitator. He is merely a facilitator without any adjudicatory powers. So this is the, this two important aspect from the Supreme Court also highlight that the code is going to be a very successful in the near future to come. And one aspect that during the COVID that happened is that this has been, as per the 5th June ordinance, considering the lockdown, many companies are now maybe in a situation to, face the insolvency aspects. They will not be in a position to pay even the, salaries, or they will say that we don't have. Of course, if it is true, and or the Insolvency Bankruptcy Board of India is also there to support them. So it is with that thing in their mind, they have suspended. They made the suspension of Section 7, Section 9, and Section 10 by saying that it will not be the suspended, and that means they will not incorporate any proceedings during this tenure of COVID. And of course, it is 6 months and it may extend to 1 year. But till 1 year only, they have stated that. And they, for this, they have inserted a new provision, that is Section 10A, where the suspension of the initiation of the corporate insolvency resolution for the period. So by introducing or introducing a special amendment, that is Section 10A only, they have made an exemption to it. Now, one aspect that comes to my mind is relating to the Section 66. Section 66 also has been, which deals with the fraudulent trading or wrongful trading. As I told you that Insolvency Bankruptcy Code, it also includes even the criminal perspective is also in there. Now, here there is a need for proving that intention to defraud the creditors. So if during this COVID period, if fraudulently or anything that is fraud is committed by the companies, then they are actually exempted from even the criminal liability. So during this 1 year or 6 months, if any company is wrongfully, that is, even if they have the capacity, they said that no, we don't have, and if they do any of this sort of thing, whether they will be excluded. But if we go with the literal meaning of the provision, then I think that they are exempted even from the criminal liability. So this is the things which we have to wait and watch, that how it will develop. And now we can say it. So this is again, so bankruptcy actually a long-standing commitment for a country. It's a long-standing commitment to help the people to get a fresh start. It is not to see that the companies are getting liquidated. Instead, it is a help. You can see that when you are going to sink or when you are going to fall down, there is some other person who are very in a position to lift you up. That person is lifting you up to be with him, and then he will encourage or to start fresh again. And the principle has never been giving only the certain people a fresh. So it's actually to give a fresh start again. And it means that what is important is that when we are nowadays talking talking about the hygiene, health, health hygiene, then social distancing and all these aspects. I will say that this bankruptcy code, the companies are expected to have the health hygiene. They're expected to have the health hygiene. That means when you are borrowing, try to see that you are in a position to repay it, or you are doing such kind of business which will give you again a opportunity to recoup. Of course, upside and downsides are part of our life. As for the company also, it is, we cannot say that, we cannot deny it, but at the same time we need to see that the health hygiene of the accounts of the company, or that is also the company's health hygiene also preserved in the COVID times, so that don't go into, and today also in the newspaper, the Reserve Bank, they, of course, banking companies are there, so they were saying that the growth of NPA is also again going to be increased. So this is the scenario, because now they were thinking that, of course, this code will help and NPAs will, reduce. But this COVID scenario, it is not only in this commercial setup, and commercial or the business setup are the more affected along with the people or along with the country. So the NPA, we have to just wait and watch how it will come up. And I also wanted to share one important, since many of students are also there, and of course maybe you are aware also, and if you are not aware, I happen to come across this, that a national online quiz competition is conducted by the Insolvency Board. Okay, and it is open from 1st July to 31st July, and they are giving you a lot of prizes. So there is like an online quiz, and it's like, the timing and all has been set up, and if you're the winner, you will get, I think, gold medal and 1 lakh rupees and bronze medal. So it is open to all the students. It's not only students, teachers also, it is open to all. So you have to answer it within that minutes that they have been set up. There is practically also you can check, because they have given you the, if you go to their website, you can find it. And I will say that try to participate in this quiz and see what questions they are asking, because sometimes it may be the real issues that the insolvency uh, commission has been facing this. So with this, I end my presentation, and I would like to, if any doubts are there, I'm there to clear. I hope that I was able to give you the brief understanding. It's a theoretical part only I have given, understanding of the IBC and insight into it and how important it is. And in the future, we can see that this code will have, definitely will be, if give a future for, or the companies to survive or to revive. And if the companies are surviving, and the bankers or the creditors will also be in a position to come up, and if everything is fine, then the country will, because banking is the kingpin of the chariot of economic progress. So economic progress of the country depends upon the banking and non-banking financial institutions. And if it is true, then the companies are also playing an important part, and with their help of, if they are facing any difficulties, with the help they can come up, and then it will help to revive them. So this is a positive side to help the companies to overcome it with the limited frame or the time frame. Thank you.
Thank you, ma'am. Now I'll start with the question.
Yes.
So the first question, which is asked by Mr. Shivam Chaudhary, is: can provision of Debt Recovery Act and IBC be read together?
Yes, see, the IBC never says that you should not, go with the other legislation. And this is one of the things, people, even the financial institutions are not taking, many a times hesitant to take up this insolvency bankruptcy code, because here the process, they are only helping you with the professional help or professional expertise to recoup it. And debt recovery, you are, taking the matter there, and it will take its own time to come up. Okay, so there is no as such restriction imposed on it.
Second question is by Shishmita. To whom, Shishmita wants to ask to whom the act applies, only to the companies or any individual?
It is even applicable to the individuals. It is applicable to the companies, partnership firms, individuals, even section, I told you that the person, section 3, subclause 23 defines the person resident outside India. So even the persons includes an individual as well.
Okay. Another question is, who is the regulator for matters pertaining to IBC in India?
Insolvency Bankruptcy Board of India is the regulator at present who regulates it. And the adjudication is by the National Company Law Tribunal.
Another question is how IBC is able to keep up with the time-bound practice.
Actually, very interesting question again. The time frame that has been made, they are trying to keep it in a time, 170 days, 290 days. So it's in a time bound manner they are doing. And the way the legislation has been amended also, you can see that how proactive they are. They're actually proactive in their way that they wanted to get a quick remedy. And the Bush and Still case is one of the example where within a year the process has been settled. So till today we can say that it is going in a speed manner and the time manner, and now we have to wait and see that how much, whether it will take the court route to take years, 10 years or 20 years again. But till now it is going in a very quick manner only, I will say. Because if we compare to the UK, this Indian legislation, they have kept the time frame that within this 280 days maximum and all these things. But in the UK, they have not said. Considering this, because we will do only if there is some pressure on us. Without pressure, we will not be in a position to do it. So legislation also thought that let us pressurize them so that companies also sort out their issues and be very quick. Because even if the companies are going in the liquidation, the assets can be sold and we will get some value for the assets. If it becomes 20 years, we will not get even the value for the assets, even if we wanted to get it liquidated. So that is the scenario.
Another question is by Raman Sharma. What is the difference between liquidator and resolution professional?
Liquidator
and resolution professional.
See, liquidator is the person who is appointed for the liquidation process, that is the far end of the process. Whereas the resolution professional is actually, we can say that, if I am sorry to use the word, a broker person. To make the financial creditors and all come together in a table and come up with the solutions to agree with it.
I think we'll go towards the last question. Last question is by Noel. He wants to ask, is the bank under an obligation to honor the performance of bank guarantee if invoked by the beneficiary principal during the contraction of CIRP?
Please again repeat it.
Is the bank under an obligation to order the performance of the bank guarantee? The first half of the question. Honor the
bank guarantee.
Right. If invoked by the beneficiary principal.
I think this is the question is not actually clear, but if it is relating that once the moratorium is invoked, I don't know how the question. If the moratorium is declared, then they can't, because once the process has been initiated, so till that time you have the time to settle. But once the if you start the process, then through this resolution, people only they have to come up. So bank cannot accept the guarantee also at that time. It's my understanding.
Okay. Thank you so much, ma'am. It was a really informative session. Now I would request our academic coordinator to present vote of thanks.
Oh, thank you. Thank you, Stuti. Ma'am, the speaker today, Dr. Shushmita Malaya, it was a pleasure listening to you and the students and faculties who have been participating in this webinar. I'm sure that a great understanding of this IBC has have been helpful to them. And I'm sure there are many questions, ma'am, relating to, they want to know what is the link for the competition. So if you could share that with Stuti, it will help them.
Competition, yeah. So it is go to the website, no? Insolvency Bankruptcy Board of India website. Just give me a minute. You can Google that. Just insolvency.
Otherwise, ma'am, Stuti also will look for it and she can search it and send it to the participants.
Just, see the link. This is the one. Can I again share this?
You can share it in the chat. Or you can send it to
ID. Yeah.
Ma'am, you can send it to me. I'll send it further.
Madam, you send it later on. Don't worry.
Okay.
Send it to Stuti later on, then she will
I have shared it, the link in the chat box.
Thank you.
Okay,
wonderful,
so
ma'am.
yeah.
Thank you very
and
much.
I want everybody of you can also participate. They are saying that I happen to listen to them, so they said that it is open to all, and they will give certificate also for those who are participating. It's not so easy questions. I also try to attempt it. It's not so easy, but still they are encouraging the people.
So wonderful, ma'am. From your discussion today, many of the students and faculties have picked up a great deal of the theoretical aspect of IBC. And it is a pleasure listening to you. We'll get back to you for any other. I'm sure that you'll be part of our, resource person in other events and assignments. So we will be in touch with you. Thank you for this greatly informative session. Thank you once again.
Thank you, organizers again. Thank you, Stuti. Thank you, Yogesh sir, for inviting, and of course, ma'am. It's really wonderful because it's a very good topic. Also, you have taken the workshop regarding this. It's a very, I will say that emerging areas you are always picking up. So I'm happy that you're taking this. So thank you for inviting me and giving me an opportunity.
Thank you very much, madam. We are very much grateful to you that you have been devoting your time. So now we will be closing today, and sometimes in future we'll meet again, madam. With that, okay, madam. Thank you.
Yes.
Thank you.
Okay,
Thank you all the
sir.
participants. Okay.
Thank you.
Thank you.